Happy Monday morning to you. Welcome to another episode of Monday Morning with Mo. Good morning, everybody. Welcome to another episode of Monday Morning with Mo. I hope you guys had a great weekend and are ready to tackle the week. If it's your first time joining us, hopefully it's not, but if it is, this is Monday Morning with Mo. Every Monday at 8 a.m., we do this little show right here on Facebook Live, YouTube Live to answer your legal questions. So if you have legal questions out there, feel free to email us, ask@dewittlaw.com, or you can leave us a voicemail, 407-536-6737. Happens to be 407-53 Moses, in case you didn't know that. Leave us a voicemail, I'll answer it right on the show. So, keep them coming, or post in the comments, shoot me a DM, whatever you want to do, and we'll answer those legal questions for you. So, hope you guys had a great weekend. We took the family over to a showcase of citrus on Saturday, over in Claremont, Florida. Cool little place. It has like a petting zoo. I guess it's a working farm. They have like a monster truck tour, cool little bar, some stuff like that, some food trucks. Good little time. I posted a video on Facebook and my TikTok if you want to check it out. Let's see, this week's Cinco de Mayo. So if you're on our mailing list, you should have gotten a Cinco de Mo magnet in celebration of Cinco de Mayo. If you're not on our mailing list, I think it's on our website, dewittlaw.com, that you can join the mailing list, or just message me and I'll add you to it. And, let's dive right into it because there's no time like the present, right? So, got a few emails here this week to get through. Hopefully there are some interesting questions, and if you guys have questions about them or questions about anything, put them in the comments below. Happy to answer them. So, all right, first up we got Jimmy. Jimmy says, I was on my motorcycle with my wife when another driver was driving crazy. He pulled in front of me and brake checked me. I was able to avoid him. He then switched lanes and came back and did it again. This time, I couldn't avoid him. The police came out and did an accident report, but they didn't find either party at fault. Do I have a case against him? I've been in so much pain, I've missed 3 days of work. Well, that doesn't sound like much fun, Jimmy. I hope you're doing a little better now. So typically in Florida, if you rear end somebody, if you run in the back of their car, there's a presumption that the person that you hit, that you're at fault. If you rear end them, there's a presumption that you're at fault. However, it's a rebuttable presumption, so there are exceptions. And one of those exceptions, one of the very common exceptions, is someone cut in front of you and then slammed on their brakes, causing you to rear end them. Because in that situation, it's not an issue of you keeping a safe distance from them because they cut in front of you, essentially causing the accident. So what you would need to do is try to gather evidence to show the insurance company that the other driver was at fault. So the best way to do that is if there's any video in the area. You're going to want to check if there's banks or businesses nearby that might have video that show the accident. You want to act quickly on that because you don't know how often those videos are deleted. I actually had someone call me about 11:30 last night down in Marathon, Florida, and they had an accident there. And it was a similar situation where the police weren't going to find either party at fault, but they did mention that there was two businesses nearby, one being a bank, another being a restaurant, and both had cameras. So they were going to pull the camera footage there. And so after an accident like this, you want to sometimes the police will do it, a lot of times they won't. But if you hire an attorney for your case, they can send what you call a spoliation letter to that business. And the spoliation letter basically requires that business to preserve the evidence. So hopefully they'd let the attorney view it so they can actually see the video, maybe even download or make a copy of the video. But at the very least, it allows it to be preserved if the case goes to litigation so that you have that evidence there and can produce it as evidence, hopefully, in your favor. So it sounds like you may have a case against him, Jimmy. If you want us to look into it for you, give me a call. You know how to get hold of me, and we'll go from there. So always good questions there. Let's take a look here. Next up, we got Mark. Mark's got a little bit different of a question, but we'll try to answer it here anyways. Mark says, I own a restaurant and wanted to know what a restaurant can and cannot do with a service dog. What are the restrictions / regulations? I was trying to find something online, but it all seems to be vague. All right. I think we had this question asked a long time ago on the show, and I forget the context. It was probably when we first started doing the show. So there's a big difference between service animals and emotional support or comfort animals. So a service animal is protected under the ADA, the Americans with Disabilities Act. Has very strong protection. If they're brought into a restaurant, the restaurant owner really can't, the restaurant owner has to allow it. They can't deny service. That would be a violation of the ADA. You'd be facing a pretty good lawsuit there. Emotional support animals or comfort animals, they're often used as part of a medical treatment plan, as therapy, but they're not considered service animals under the ADA. So for a restaurant owner or anyone who owns like what we call a public accommodation, so restaurants, theaters, hotels, healthcare facilities, all that kind of stuff, there's 2 questions and only 2 questions that you can ask to determine if an animal is a service animal. So one, you can ask the person, do you need the animal because of a disability? Don't ask them what the disability is. It's a yes or no question. Do you need the animal because of a disability? Second question is, what work or task, or tasks, plural, has this animal been trained to perform? So here, the second question is really key. Because if the person's unable to identify the work or tasks that the animal has been trained to perform, then the animal is not a service animal. So that would then qualify probably more as an emotional support animal or comfort animal or something along those lines. So if you're someone in the public accommodation business, restaurant, hotels, things like that, those are the 2 questions that you are allowed to ask, and that you may want to ask if you're having an issue with people bringing animals into your establishment. So, absolutely want to make sure you're allowing service animals, ADA, compliant animals, emotional support animals, or comfort animals. Those would not fall under the ADA, and there's other regulations that may go along with those, but typically they don't have the same protection as a service animal. So, hope that helps you, Mark. I know that's always an issue that pops up every so often, especially with more and more maybe not so legitimate support animals being out there. Not judging, not saying anything, but we've all read the stories. Let's see. Next up here we have Sam. Sam says, my wife's ex sent her a text about wanting half of the stimulus money for their son. He hasn't claimed him on taxes in over 5 years because he says he's paid under the table, even though their first court papers say they get to claim him every other year. The last 2 times he's asked her to claim him, we gave him half. Now he's threatening lawyer stuff again toward her, even though he hasn't paid child support in years. I believe last she checked, he's over $16,000 in back child support. All right, so I think we've also had this question quite a bit on the show about the stimulus payments. Who gets it, things like that. Here it's a little different. If he owes back child support, I think that the most a court would ever do would, probably take half of the credit for the child and apply it towards his child support arrearage. Typically most courts have been splitting the stimulus monies based on the percentage of the overnight. So if you have 50-50 custody, the stimulus is split 50-50. If it's 80-20, same thing applies. Here, though, I don't think they would ever really make your wife in this situation cut a check to the other party. I think they're more likely to just apply it to his back child support since he does owe so much in arrearage. So, he can threaten all he wants, but I think that's probably his best day in court. Again, I could be wrong. Been wrong before, but that would be my prediction there. But what I've seen most judges do is just split it based on a percentage of overnights. So that's what we've been seeing on most cases. So last up here, I have one last question for the show. This comes from John. John says, got a question for you. That's what we're here for, John. every Monday morning at 8 a.m., as you already know. Does the mother of my daughter need permission to change our daughter's last name? She has my last name and she wants to change it. I'm guessing this is probably maybe a little bit of a contentious relationship there. So she doesn't necessarily need your permission, but she would have to file paperwork with the court and give you notice. So if you won't agree to have the child's name changed, then the other parent has to request the change. They have to go to court, see the judge, and you must be served with a copy of the name change paperwork. So it's just like a lawsuit, basically. She has to go to court, file that paperwork, and that process server or the sheriff has to come out and serve you with it. You have to receive proper notice of it. And then at the end of the day, a judge may or may not grant the child's name change, depending on what the circumstances are. If you don't consent, ultimately it'll be up to the judge. He'll hear arguments on both sides as to why the name change should or should not be granted. And that's basically it. So, it doesn't necessarily need your permission, but can't really do it without your involvement. So, just make sure if you are served with that paperwork, typically there'll be a summons. At the top of the summons will say how many days you have to reply to it. Usually it's 20. If that's the case, make sure you reply in a timely manner. If you don't reply in a timely manner, she may win by default, and then she won't need your permission. So, I hope that helps, John. If you guys have any legal issues out there, let me know. We are here every morning, 8 a.m. Also here on Fridays at 7 for the Soul Brother Kevin Show. Broadcast that live on Facebook as well. Hope you guys have a great week. Stay safe out there. Have a good Cinco de Mayo. And we'll see you next week on another episode of Monday Morning with Mo. Take care, everybody. Have a good week.